for example, Department of Defense, when I used to work for Northrop Grumman, there was a pilot program for IP, and they actually changed the regime, IP regime, which means that they changed it from full ownership to just pure licensing. So the actual creator or the contractor or the consultant now, if you're working in defense contracts, can actually own the IP, and all they do is give them a broad license to the government. That way, it doesn't inhibit smarts or innovation and collaboration in the industry, which is what defense just does so well. And I'd love to see that one day in construction, engineering, manufacturing, and infrastructure. That environment, that the IP regime model changes. It's from full ownership of everything and just putting it on the shelf because we paid for it. We'll put it on the shelf. We can do whatever we want from that mindset to you can have full ownership, but give us the broadest license and a perpetual license to maintain that. That would be the best outcome for the industry.
Hi Veer, welcome to the Digital Construction Podcast. How are you today?
Good, how are you going, Andrea? It's been a while.
Very good, very good. So in this episode, we sit down with Veer Dhaliwal. Veer was named a finalist at the 2024 30 Under 30 Construction and Infrastructure Lawyer of the Year. He worked for Transport for New South Wales, Arup, and today we're going to talk about the legal aspects related to digital transformation. Veer can share with us a little bit of his career journey later on. But before we start, Veer, I have an icebreaker question for you. What's the best piece of advice you've ever received in your career?
Well, I'll be very simple and transparent. The simplest piece of advice and the best piece of advice I've ever gotten is if you don't ask, you don't get.
And so jobs.
Yes. In jobs, if it's in terms of career, in terms of asking the right questions, don't be afraid to be open, vulnerable, and asking, hard questions.
Beautiful, thanks. Yeah, I've heard this from Steve Jobs as well. There is an interesting video on YouTube. I think it's called Steve Jobs Asks or something like that, where he says something like that, basically. Yeah, it's a very, very good piece of advice. But Veer, can you start telling us a little bit about your career journey and what led you to work into the legal space for the construction industry? Okay,
so for me, throughout my career, it's been peppered with intellectual property work and experience. Funny enough, although I'm a lawyer, I was always meant to be an engineer. I started engineering and then switched to law and science, and that's where I picked up intellectual property. And I've made my way to organizations such as Balcombe Lawyers, Northrop Grumman in defense, and then on to Arup Engineering Services. So that's a global tier 1 organization that provides design engineering services. And then I went on to Transport New South Wales, one of the most recent organizations that I've worked for.
Yeah, that's very good. Although you are relatively young, you have a very interesting career and your skills are very valuable. So it's interesting because today we talk about the digital transformation from a different point of view, which is the legal aspect. But just to start, from your point of view, why should construction professionals and being manager care about the legal aspects related to the digital construction? Because I don't know if it's obvious, but I just want to know your opinion about that.
Well, that's a great question. Digital construction and BIM, I think that we're all talking about, it is just isn't just a design tool anymore. It's a shared digital environment that's part of your contracts and your liabilities and risk exposures and those frameworks that you operate in. It's pivotal in terms of driving innovation forward for the industry. For example, if organizations and clients want to own IP, it may, withhold innovation in the industry. and it's pivotal to creating master, buildings and etc. Something that's unique, and you'll see those in Dubai, for example, or in the UK, the Shard. Those require all BIM and master planning to take place. So understanding the legal environment of how they help protect the project and the people behind it turns, collaborative environments into clarity instead of confusion or claims that may arise later on after the project. And BIM's very pivotal to that there's a real environment model that exists.
Yeah, that's very good. And have you, you've been helping companies, you've been helping government agencies. I'm sure you've seen some challenges, but what are some of the biggest challenges that you've seen companies face when it's about developing BIM or digital tools?
Well, in terms of, I guess, the biggest problems or challenges or headaches, I'd say it would be in relation to data ownership. Who actually owns the model or the IP? Who gets to use it after a project ends? Who really owns it? Is it the client? Is it the contractor or the consultant? Or is it the person who created it, the models themselves? Or is it open source and no one owns it and they can freely commercialize? Secondly, it's around liability. If someone, for example, relies on a model data or a model, and it turns out to be wrong, who's actually on the hook? Who's going to be able to be, liable? Who can the client or the end client or the government claim against if something's wrong? For example, misalignment of bridges. That's something that's probably been in the news recently, or may not be, on projects. Then there's IP protection, particularly when there's multiple parties and that contribute to one federated model. And finally, actual clarity on contract terms. Lots of contracts just aren't built, and they're not actually implicit or explicit in terms of the digital workflows and keeping those in mind of how does BIM actually form part of the contract. Is it at project inception, or is it after? From my understanding anyway, it's generally after the project kicks off is what's the protections around all the liabilities and risk profiles and exposure. How is it actually curtailed and made bespoke for the actual contract where there's BIM involved? So addressing these head on is, something that we should stay on top of.
Yeah, very good point. And at the beginning of your answer, you touched on IP rights, intellectual property. I want to ask you the straight question. Who owns the BIM model? Is it the designer, the contractors, the project owner? Who owns it?
Well, that's a very pointed question. It's very loaded as well. It really depends. It really depends. And I know it's a typical legal lawyer response. It really depends on the contract, the actual terms, and how BIM is being expressed or incorporated. But it's generally the person or company who creates a piece of work owns the copyright, as you would know. In Australia, it's actually established that it's at creation. It doesn't have to be assigned or etc. But with BIM, it's a collaborative environment, as you would know. So you might have designers, engineers, contractors, and even asset managers all collaborating and contributing to the actual BIM model. So best practice, I'd suggest, is to clarify this at project inception and spell out who owns what, who has a right to use what, and under what conditions. So what model, what type of IP, for example. And for example, does a client get a license to use the model, or do they have full ownership, or is it a perpetual license so they can continue to use the model? Can they modify it? These are things that matter a lot later on once the project's on foot or the project has been completed.
That's a very good point. Is things that you need to set up, and there is no clear answer. Like you need to. It depends on how you write the documents, I guess. What are, from your point of view, the legal risks that we have when we share BIM models? Because we have these files, as you mentioned, multiple people working on multiple files, and now we share these files, and sometimes there is things that people shouldn't know. So what are the legal risks that you see?
Okay, so again,
It depends.
I can all, no, not just that it depends. It all begins at the start of the journey. That first conversation that you have, either under a confidentiality agreement, NDA, or just a coffee, is how does the project start? Is there a framework? What are the contract terms? And having the right IP clauses in there, licenses and usage rights defined clearly. You need to think practically at the start, and limit basically editable rights to only the people that can edit. And in terms of the files, watermarking them if they're in draft or protected. It shouldn't be, and it's to be best practices to maintain a controlled environment that's collaborative enough to share with one party or the other. And when you're working across multiple companies, joint ventures, or large, government to client and shared environments, it's really important to set the ground rules for IP early on. And it could be in terms of a BEP or a BIM execution plan at the beginning. Generally, it's after the fact, though. That's the realistic and practical application of BIM and management of BIM rights, and who owns and who shares and who collaborates. I understand it's after the fact, but I'd love for the industry to get to a point in terms of IP and smarts, and BIM being one part of them, that we think about these future innovations well ahead, because it does lead to greater innovation if there is understanding, either it's licensed or full ownership, or assignment of ownership of IP, which includes BIM models.
Yeah, very good point. And I feel like after this explanation, the best way to protect yourself is to speak with somebody like you, speak to a lawyer before you start the project, and don't assume that you get it right.
Yeah, so I'm quite passionate about IP and smarts, and I've seen that in multiple industries. That, for example, Department of Defense, when I used to work for Northrop Grumman, there was a pilot program for IP, and they actually changed the regime. IP regime, which means that they changed it from full ownership to just pure licensing. So the actual creator or the contractor or the consultant now, if you're working in defense contracts, can actually own the IP, and all they do is give them a broad license to the government. That way, it doesn't inhibit smarts or innovation and collaboration in the industry, which is what defense just does so well. And I'd love to see that one day in construction, engineering, manufacturing, and infrastructure. That environment, that the IP regime model changes. It's from full ownership of everything and just putting it on the shelf because we paid for it. We'll put it on the shelf. We can do whatever we want, from that mindset to you can have full ownership, but give us the broadest license and a perpetual license to maintain that. That would be the best outcome for the industry.
Yeah, that's great. Another terms that people don't mention often is the fitness for purpose in BIM, and probably people developing BIM models, working on projects that are not maybe necessarily thinking about this specific definition. But can you explain to us what fitness for purpose means in the context of BIM and digital models?
1 second. Yes. It's really, fitness for purpose is a really important term. It's a term that implies a deliverable will perform exactly as it's intended. Like, it won't be, what's up to someone's skill or their understanding of, what's required. Rather, it's exactly as it's been described. Not just, it was created for with, skill and care and with duty of care of an engineer. So, if, for example, if a BIM model is used to fabricate, components, and something slightly off, like, I don't know, a millimeter or centimeters, for example, that'd be quite a lot if it's centimeters. Even slightly, you could face a claim if the model was contractually meant to be fit for that use. So in the contract, if it said BIM models are to be fit for purpose, then they have to be exact And BIM models are like, they're down to the micromillimeter and so on. So you work in a digital environment, you can specify as small as you like or as large as you like.
Very
And
good
if
point.
someone's
Yeah. Sorry.
and so again, contracts are just, they need to clarify whether a model is for coordination, for reference, or for construction. What is it actually for? And you can, include disclaimers in the models itself, which doesn't necessarily protect you. just so that, caveats and disclaimers don't necessarily protect you. Instead, IP should be very particular and reviewed by a specialist like myself or yourself in collaboration, and understanding what's the end goal, what do we want to do, what do we want to protect, and these are some of the risks that will come up. Fitness for purpose is it should be subject to your skill.
Yeah, what are the legal implications? Like somebody's been working on a project, they build this digital asset. It could be a digital twin, and what can possibly happen if the model doesn't meet its intended function?
Well, some of the disputes or claims that I've seen in the past in recent times is some of the common problems is models being used for purposes they weren't intended for. Conflicting information between the model versions, what type of BIM level it is and so on, and it just doesn't correlate or, mesh together. Delay claims from incorrect data being provided in a model. So if someone were to, fitness for purpose again, relying on that, if they were relying on a piece of model and they had a time frame or a program to meet for construction or otherwise, and it was delayed because it was an incorrect model, they're delayed, then there'll be a claim based on that delay. But if it was in terms of it'll be a BIM model, more generic terms, etc., and you work collaboratively in order to get there, then there may not be a claim necessarily, because there's an understanding of collaboration, not this will be fit for that purpose in that time frame. For example, it's more generic, it's more flexible, and collaborative in nature, rather than it's fixed. You deliver this at this time, and you get paid this much. But if you don't deliver in that time and with that standard, then what happens? The project gets delayed. No one wants to pay for it except the contractor or the BIM provider will have to pay for it. Or lastly, it's something that's more common than anything else and prominent, I would say, in the construction and digital environment is misuse of IP between contractors and subcontractors. They can take one BIM model that's amazing on one project and take it to another, but they have no rights to do so. So to avoid all this, just have a clear BIM execution plan at the start of the contract at the inception, and lock in, version control of that plan, and make you sure that the dispute resolution clauses are actually tailored to digital workflows, BIM. And it's worth having those, mechanisms early on in the contracting phase, and understood how things can escalate, meaning they can be pushed up the chain and resolved at that higher level without it leading to a claim.
Okay, yeah, good point. And I think we are working on this on these projects. We have multiple people with multiple responsibilities. So how can we use the contracts to then define and allocate the responsibilities related to the fitness for purpose? Yeah,
so in terms of responsibilities and fitness for purpose, I'd recommend that the BIM execution plan, because it's let's just think of it as an adjoining document to the contract. So if it's incorporated into the contract rather than a document that gets created after project is on foot and a contract has been signed, that means everyone has an understanding of how the BIM will function and how it will be supported throughout the project, rather as the journey progresses and you go from one milestone to the next milestone. If you have the BIM execution plan at the beginning, that's been understood even to the broadest brush, some kind of understanding of how BIM will be shared or who will own it, how it'll be incorporated, then you can soften some of the contractual terms. So fitness with purpose can then exclude BIM if you want, for example. It can be subject to your skill and care, and BIM can be more collaborative rather than it'll be fit for this. And there's no BIM execution plan. Then there's no understanding of BIM. BIM is just then another item under IP. For example, IP, definition of IP includes models, circuits, circuit layouts, source code, etc., etc. Then it's no longer a smarts. It's just another deliverable. And it has to be fit for purpose, because BIM, the BIM environment, digital construction, is an ever evolving and changing environment. It has to be collaborative. Otherwise, you're going to get stuck. And there's going to be a lot of claims. And there have been in the UK, and generally it's starting to become an issue in Australia as well.
Yeah, very good point. And I'm glad that you mentioned the BIM execution plan, because speaking even with other digital leaders, I've noticed that I'm not sure people pay enough attention to it. It's important. It's a legal document, and you need to make sure that you pay attention to it. Because then that can lead to claims and disputes. So sometimes, even if you prepare all of the right documents or you've done everything right, at some point you end up in a dispute. So
you do. Yeah.
So what are the most frequent claims that you see arising from BIM-related issues?
So again, generally it's to do with the delay claims. So for incorrect data in the models that just don't match their client's requirements or real world application, or it's in regards to models that aren't functioning to how they're supposed to function, so the intended purpose or fitness with purpose, or implied use of those models, and then it's the misuse of IP between contractors and subconsultants and so on. It's third parties having the ability, when there's no version control and no specific individuals that have rights to editing the actual models. And it's just anyone. It could be an agent, it could be a third party contractor that's only there for a week in the environment and thinking, oh, wow, this is amazing. It's 4D, 5D, whatever version of BIM it is, and that they take it to another project, because there is all that calculation and that work flow and workings underneath the models that engineers have put so much time and resources into, a lot of love, that's then taken to another project where they have no rights.
Yeah, good point. And how do courts typically view BIM-based claims? Like, how do they treat BIM disputes in courts?
Well, at the moment, it's a changing environment. So in Australia, it's just starting out. So whereas in the UK, there have been a number of cases on BIM, whereas in Australia at the moment, it's just deliverable, just part of IP. So it's viewed in a larger context rather than as its own claim in itself. So it's a journey we're in at the moment.
Yeah, it's interesting because technology evolves and the law has to catch up with the technology.
It's not there yet. So thankfully in Australia, the claims haven't arisen, but they have arisen in the IP context or the claims context of deliverables. So if there's a delay in deliverables, it's claims and so on, milestones. But it's there. It's definitely there. It's starting. There's been a number of tested cases in Australia, I think about 2 to 3. But if you look at the larger construction context of deliverables, which BIM currently falls under, and IP, then yes, there have been a multitude of claims.
Good point. And you just mentioned Australia, but often people work on projects in other countries or international projects. And I was wondering, from the international point of view, like, how do BIM and digital legal framework differ across different regions?
Yeah.
So, for example, the UK, Europe, United States, Australia. What's the difference between the different areas, geographies?
So it's definitely getting more complicated in the other regions. There's been a multitude of cases being tried in the UK jurisdiction. And so they're all, even the EU, they all have different laws and data ownership, privacy, and IP. For example, in Australia, we have the Privacy Act, but then in the EU, it's the GDPR Act. It's more data-related, data-friendly, whereas in Australia, I would say myself, it's more generic in nature. But it is strengthening in terms of protections. But for BIM in particular, the UK uses ISO's, I believe, 19650 standards, and the EU has very strong privacy-like regulations and data protections under GDPR. And so it doesn't necessarily in Australia have a strict BIM legal framework, but it does follow, ISO 9650 in some of the sectors. So you need to define jurisdiction, governing law in your contracts, make sure they comply with the local regulations and laws. But it's essential to seek legal advice from IP experts or experts in the digital construction area to actually better prepare yourself for contracting in collaboration with other parties. Otherwise, you may end up in that disputes area and claims in the future instead of collaboration and working out a solution and escalating rather than go straight into claims.
Yeah, good point. And often we see situations where a project may be like the building or the infrastructure may be located in, let's say, Australia or the UK, but the team that or US, but the team that delivers the project could be somewhere else, could be in another country, could be outsourced in Asia, for example. So what are the challenges that you see arise when working on international projects that with different regulations in different countries, depending where the people that actually deliver the projects are?
So, funny you say that, and something I've actually recently encountered last week. It's in terms of, professional services. It's a type of professional service that they're providing, an indemnity. And so that's what professional indemnity or general professional indemnity insurance covers all over the world, is a type of professional service or engineering services. And the challenge is if someone's providing services from one region or one country, because generally laws are prescribed to and limited to a jurisdiction or a country, to another country, how is that client from the other country going to put a claim against that service provider from another country if they don't have an office there? What value is the insurance policy? That's an ongoing challenge. But one way to do that is if there's a retention sum, if there's milestone payments involved rather than lump sum. So I've seen government working at transport, for example, recently is this 100% payment upfront for SaaS products up to an X amount. So it's having milestones in place that, hey, if you don't deliver it by this date to this standard, then we won't pay you X amount of dollars. We'll only pay you for what you complete, the level of detail, and that's for BIM, right? It was a 3D, 2D, 4D, so on, 5D level of detail. If you don't deliver it up to those detail and to that standard that we've set in terms of the backing documents, then you'll only get a certain amount of payment, if at all.
Yeah, good point. And I would like to change gear and focus on some practical advice for construction professional. And this is not legal advice. Let's make sure that people understand that. This is just general information.
Okay. Sure.
So yeah, you're safe, Veer.
Sure.
just trying to focus on best practices and how do we manage the legal risk when we work on BIM or we focus on digital workflows. So what are some of the key legal consideration every construction firm should keep in mind when they decide to adopt BIM on their projects?
And so in terms of, practical tips to adopting BIM is to start with the basics. For example, for lawyers or contract managers or even engineers, professionals in the BIM environment, digital construction, is to start with using template clauses that are fit for BIM and IP protection. That are actually bespoke, not just generic in nature that talk about IP and deliverables in general. It's talking about BIM and being specific of what protections BIM gets, or is it collaborative in nature, and who owns BIM? Is it jointly owned? Was it licensed? And so on. It can be separated out rather than being incorporated into one IP generic clause. And then it's defining, model deliverables and data ownership clearly. And thirdly, it's to actually limit your liability for misuse of the model. So as a collaborator, as a consultant or contractor providing those deliverables, those models, is what's going to happen to you after the model is taken from you? Do you disclaim all liability? Do you have ongoing liability? For example, in Australia, if it's an agreement, the contract's in the form of an agreement, it's 6 years liability. If it's in the form of a deed, this is something I'm continually having to discuss and negotiate. If it's in the form of a deed, then it can be up to 12 years of liability. Do you want to be liable for your model for 12 years, for example, well after the project? And then keeping up with, evolving standards. And then it's training your staff on the legal risks. Often, come from people just knowing how their work ties into the contract. How does it actually, what's the interplay or interconnections between the actual models and the contract terms? And do they know what BIM is? Does the legal team in your organization or do the contract managers understand what BIM is, or is it just, again, something off the shelf, something you can just throw away after the project's done? What if the client later on comes back in 6 years, 5 years, for example, or 5.5 years, and says, hey, your model was wrong, something's really wrong with the project? Even small firms and teams can, manage risk if they're proactive and structured in how BIM is defined.
Yeah, very good. And thinking about the future and the future of the legal framework around digital constructions, how do you see the construction law evolving with the rise of AI and automation tools in BIM?
So I see it evolving in a nature of collaboration, and there being a shared understanding of BIM and allowing the actual creators of BIM models having ownership. That's best outcome, as I started with, is that the actual creators have full ownership, and then provide a license to clients, because you do want to have the ability to innovate and modify in the future and update those models. If you have a license, you can come back in, you can modify, you can maintain the models to the client's requirements. Whereas the challenge and the issues that I see, again, is claims coming out of BIM. When there's no BIM execution plan in place at the start of the project inception, there's no standards that have been set, and common understanding of how BIM will interplay and continue to play out after the project's been completed.
Yeah, very good. And the legal framework is probably evolving and trying to catch up with the technology. But are there any upcoming legal trends that construction firms should be aware of at this point in time?
Construction firms are, in terms of approaching legal risks in the future, it is, not so much legal. I'd say it's more challenges of a practical sense is fragmentation, systems, teams, and contracts. They're just not aligned at the moment. Everyone's solving their own little piece of the contract or that project. But the real gains will come when we're all aligned with incentives and workflows across the whole project. And if we solve that digitally and legally, we can truly, change how this industry delivers its projects as a whole, rather than it being, I'm in charge of facades, for example. I'll only focus on facades. My focus, but I've got some BIM involved in that project for some reason, right, for a building. But I'm not a BIM expert, so I'll just leave it to the BIM engineers to deal with. And let's not think about IP or protection of IP. And then later on down the track, that was such a great project. The BIM bottles were, got some awards, industry awards. How do we replicate that? You can't. You simply can't. You've been locked away because that facade engineer that was in charge of, for example, that building project, didn't quite have the education or the understanding and support and empowerment for BIM. And it's just when we look at it all together, hey, we've got this and this and this, including BIM, let's support BIM. Have an understanding what is BIM, bring in that BIM expert, BIM manager, for example. Most teams have BIM managers, and I believe Andre worked with many of them in the past at Arup or otherwise. So it's just, a collaborative effort. That way you understand the risk exposure and the innovation and the gains that are possible at the end of the project or after the project.
Thank you very much for your time, Veer. I'm sure the audience has learned a lot about the legal aspect of the digital in construction. Thank you. Have a great day.
Thank you, Andrea.
Thank you. Bye.
Good to see you again. Cheers. Thank you for your time. Bye.